Hello and welcome to the Lancet 177. Two pieces of proposed laws, the Employment Relations Act Bill and the Work Care Bill, have been in the news recently while it is undergoing public consultation process. But questions linger over how some parts of the two bills will affect the normal Fijians, the workers and the employees. Today joining me on the Lancet 177 is lawyer Jon Apted, who will discuss in detail what these two bills. Mr. Apted, the first question is the two pieces of proposed legislation, the ERA bill and the Work Care Bill. In a gist, what are some of the new things coming in these two proposed laws?
Okay, it's easier to cover the work care first. At the moment, workmen's compensation or compensation for accidents is covered by the ACCF, Accident Compensation Commission of Fiji. There are three kinds of situations where you get compensation: compensation at work, compensation for accidents at school, and motor vehicle accidents. There have been issues with delays within the ACCF in processing these claims. So the decision has been made to shift workmen's comp, the compensation for accidents at work and accidents at schools, to the Ministry of Employment. And they used to do the workmen's comp many years ago. So that's being shifted back to the ministry. There are some issues with that legislation, but that's a small problem, and I'll come back to the issues later. The Employment Relations Act, though, is a massive and very, very important piece of legislation. It affects all employers and all workers in Fiji. There are 142 sections. Those sections make more than one amendment in many cases, so there's hundreds of amendments being made in this legislation. And I can cover some of the things later if you want to talk about them.
We'll talk about the implications, but let me ask you, has the ERA bill gone through the necessary processes of where it is now in terms of consultation with the people or entities that will be affected?
Personally, the ministry will claim that it has. Personally, I would respectfully differ. I think that it hasn't, and let me explain why. Let me explain what's happened up until now and what will happen and what's wrong with it. Where this started, the whole process up until now has happened within the Employment Relations Advisory Board, ERAB, right? And this is a tripartite body within the ministry with 4 employers reps, 4 union reps, and 4 government reps from the ministry. This initially was a project sponsored by the ILO to bring our ERA into line with the ILO core conventions and the conventions that we'd signed up to. So that was the limited remit initially. However, it then turned into a full review of the Employment Relations Act. And so employers reps and union reps and the ministry put forward what the things that they thought should be changed in the Employment Relations Act. Strangely, although the union reps and the employers reps represent other groups and other employers, they were required to sign non-disclosure agreements, keeping the whole process secret. So they were not allowed to tell anybody or seek anybody's views about what was being proposed in there. So what that meant is that they never received, the employers reps only know what their own company is interested in. They don't know what other companies or other kinds of employers want. They're not technical people. They don't know the legal technical problems with the legislation. So their ability to raise issues was very limited. The unions, on the other hand, are very clear about what they want. And so they put their demands on the table, and you've got 4 reps, 4 reps, and 4 reps. And just like in Parliament, it appears there was block voting. So government reps only know the bad employers because that's the people they deal with. So with the unions, they tended to vote with the unions. And I understand that the employers reps proposals or the employers reps views never carried within there. So there's a problem with the bill as it has been circulated because it only reflects the views of the ILO in terms of their conventions, but the other changes were only the matters that were discussed by the people in that meeting, 12 people. And they don't represent the views of all workers in the country. They don't represent the views and interests of all employers. And they, most importantly, they had no, as I understand it, they had no parameters or principles requiring them to look at the effects of the proposals on job creation, on productivity, on investment, on multinationals, and so on other government departments. So in my mind, what they've come up with is very surprising, and if carried as it is, will have very, very serious consequences for all kinds of employers, for government, and for the national economy. So there's a proposal, they're saying that consultation, they were forced to bring it to consultation in December, right? They announced at the beginning of December that there would be public consultation. Unofficially, they announced that. They didn't put out the actual notice until December 28th, which is when everybody's on holiday. Most big employers are reps are overseas or at a resort. They put one notice in the paper for consultation to start on January 8th, I think, for only 2 weeks. They didn't release the legislation at all. Copies of the amendment bill were not released until to the Employers Federation until just a week before the consultation started. It wasn't released to the public until just a few days ago. This legislation tells you Section 10 is amended by deleting the word X and putting the word Y. So if you just read the amendment, you can't work out what it does. In order to understand it, you've got to do a whole exercise and show what's happening to the Act. That was never published. So then they do a consultation for only 2 weeks when people don't even know what is proposed. As I understand from the media reports, the consultation was more information. People were only hearing for the first time what's proposed. There wasn't even enough time for them to digest and make submissions. So that's what's happened. On Monday, the FCEF, which was the close of submissions, I was at that meeting, that consultation. Members of FCEF asked the minister to extend it because they were just hearing that for the first time, what's coming, and they need time to consider it and formulate a response. The minister has extended it only till this Friday, which is very short for anybody to prepare to consult all their internal stakeholders and prepare a thing. The minister and the government will say that from here it's going to the SG's office, then to cabinet, and then it will go to parliament. And the minister at that meeting indicated that a parliamentary committee will take it out again for public consultation. Personally, I don't think that the public consultation at that stage can address all of the issues. When you get to Parliament, it's already got the seal of government on it. Cabinet has approved it. A parliamentary subcommittee has the legislation in front of it. When they go out to get public submissions, they only receive submissions on what's in the draft. Anything that's been missed out in the review is not there. So what ERAB has put in here is not everything that needs to be changed in the ERA. So unless this consultation is extended at this stage, other areas where the ERA needs review that hasn't been covered by ERAB won't be reviewed, right? Also, a parliamentary committee really only tinkers with this section, this word. It doesn't redo whole provisions of the Act. That's not what a parliamentary committee does. So at this stage, before the bill even goes to cabinet, there must be much fuller opportunity for all employers and all workers and all unions that were not in a ERAB to have a say about what's wrong with the Employment Relations Act that needs modernizing. Also about what the proposals that have come out of ERAB, how it might affect their business or how it might affect their stake in the economy, like investment Fiji might want to have a say about what this might do to the economy. The Ministry of Finance will have to have a say about the effect on the payroll, and so on.
Just one final question before we take a break. What's the possibility then of a legal challenge at this stage to stop this bill from going ahead?
Well, you can't really challenge this. There's no legal right to consultation before a bill, is finalized and taken to Parliament. The remedy for anybody who is unhappy is to vote against the government. So the government is politically accountable for making sure that its legislation meets the needs of its voters and that the voters are satisfied that the process has been fair.
Mr. Apted, we'll take a short break and we'll talk about the implications of the ERA bill on the people concerned. Thank you. Welcome back, Mr. Apted. Let's talk about the greater implication. But let me ask you this question first. The minister, is he listening to the criticism coming in, and why isn't he taking it seriously?
I don't know. You'll have to ask him that question. He comes from a union background. He is from the teachers union. Maybe his experience of the issues comes from that background. I don't know, and maybe and also because I'm guessing here, but there were 16 years in which the unions were not allowed to be effective, so maybe they feel now is their time to make a change. But the change doesn't just affect them; it affects everybody. So yes, they're entitled to have their say, but everybody else should be allowed to have their say.
You mentioned it will affect government. Please elaborate. How will it affect government?
Okay. First of all, I think what I need to emphasize is within ERAB, within the Ministry of Employment, and within the public, everybody thinks when they hear the word employer, they think of big companies, right? The Employment Relations Act applies to every employer who employs somebody else. And so that includes every single individual, you and me, who engage a domestic worker, a housemaid, a gardener. The ERA, as amended, will apply to you. Government engages civil servants. Under the Constitution at the moment, it's the permanent secretary who employs everybody in their ministry. So these new rules in the Employment Relations Act will apply to permanent secretaries and make them liable for these changes. And so it's not just the big companies like, I don't know, Fiji Times or whoever. It's all of us who have somebody working for us in our house. It's the person at the bus stand who hires somebody to look after their shop, the little cafe owner. Everybody is going to be affected.
And what are some of the offenses that's been created in this proposed law that will be troublesome, if I can put it that way?
Okay, one of the biggest changes in the ERA is that a lot of things, a lot of rules that currently allow the worker to claim compensation are being turned into criminal offenses. So what this will do is not only will the worker be able to claim because you didn't pay me my wages on time, the ministry will be able to prosecute the person, right? The problem with the new offenses is there's already enough offenses to deal with this. These new offenses that they've created are what's called strict liability offenses. Normal offenses, you don't get charged and convicted unless you meant to do that thing. If it was accidental that you didn't pay the wages, you haven't committed a crime. These new offenses are strict liability. So the employer will be liable even though it didn't mean to do it. It was an accident done by somebody against directions, right? And this happens all the time in real life. Like it's not the company's fault that somebody down the line didn't pay somebody. Under this new legislation, companies, employers, not just companies, all employers, so that's individuals, permanent secretaries, everybody will be strictly liable for any of the breaches. And the fines are massive. 10,000, 40,000, 100,000, 200,000, up to 500,000 maximum penalties. It's astounding.
What would be going through the mind of a big boss of ANZ or Westpac listening to you explain this in lay term?
Well, I can't speak for them, but if I were a, I don't know, Australian bank or a foreign company, I would want to leave Fiji. Or if I was not yet here, I wouldn't want to invest. And let me explain. This is not about workers' rights, okay? This is about criminal record. You know, companies just like you and me don't want a criminal record. It's one thing to be told to pay compensation, that's fine, that's business. But to be charged and convicted with an offense is a very big thing, especially for a bank or a major corporation, international corporation. So why would you come to a small country where your returns are very small in comparison to the rest of the world and risk getting a criminal conviction for something that the employer itself didn't ask for, a mistake made by some person down the line or misconduct by one of your workers. And I'll, sorry to keep going, but the biggest example is they've made sexual harassment a criminal offense. So if the company didn't take reasonable steps to prevent it, or the employer didn't take reasonable steps to prevent it. So what that means, and it's not just sexual harassment by a worker against another worker, it's sexual harassment by a worker, even by a stranger in the workplace. So suddenly, for example, if you have a housemaid in a room, and a guest sexually harasses the housemaid, the employer, the company that owns that hotel, is criminally liable for that if they didn't train the guest not to commit the offense, or they didn't put a warning, do not sexually harass my staff. I mean, like, it's crazy. A $500,000 fine. You yourself, you have a gardener. If your gardener harasses your housemaid and you didn't give your gardener sexual harassment training, you're up for a big fine.
Do you see that this piece of legislation, the RE bill, is pro-union?
Let me just get something straight. The ER review, the Employment Relations Review, is required. It does need to be modernized, but the review needs to reflect the views and interests of everybody, including Fiji as a whole, from small employers to big employers. There are many amendments in here that are pro-union because the union has been, or the unions have been represented within ERAB and strongly represented and supported by the government side. That's fine, but they need input from others, the small employers, workers who are not unionized, overseas employers who have invested in here. So everybody's interests are reflected.
I understand one of the proposed legislation is when a worker joins a company, it's the company's responsibility under this proposed law to explain the union house and what's of the union working. Can you explain that?
Yes. What is in this new bill is that if your workplace is unionized and if the employer has a collective agreement with a trade union, when a worker is first engaged, now the employer will be required to offer the worker either an individual contract or a contract with the collective agreement and allow the worker 30 days, about a month, to choose and to follow up with the worker and do the documentation and all of that. So in some workplaces, there's more than one union and more than one collective. So in that workplace, the employer has to give all the collectives and give the worker the opportunity to choose and do the follow-up and do the documentation. At the moment, an employer just engages. It's for the unions to do their own recruiting. This legislation makes it the job of the employer to do all of that work for the union.
And how can that affect a small company?
It's a big job. You know, like you're chasing up on contracts and following up after 30 days, all of that admin is all cost. and if you slip up and you don't do it properly, you've committed an offense. You're up for a penalty. So there is huge risk to do work for somebody else. But the bigger union issue is the bargaining fee. If I can explain that.
Yes.
Are you aware of the bargaining fee?
Haven't heard about it.
Okay, so what it is that you've got workplaces where some people are in the union and some people are not. The union will negotiate a benefit for its members, let's say a pay rise. At the moment where the union negotiates the pay rise, employers generally share it with all the workers, so there's no discrimination. Under this new legislation, if the union gets agreement on a benefit, it cannot go to a non-union member unless the non-union member agrees to have 1 year's union fees deducted from their pay. So the employer loses the discretion to give that benefit to other workers, and the other workers have to pay the union 1 year's fees to get it. In New Zealand, where this comes from, it only applies if everybody in the workforce has voted that it should be applied. In Fiji, in this legislation, it will be compulsory.
Mr. Apted, we'll take another break and continue the discussion on the other side. Welcome back, Mr. Apted. We are talking about the bargaining fee and its impact. When this law was being drafted, do you think those people in the Arab committee thought high and low that how it's going to affect the normal businesses?
Like I say, I don't think so, because I don't think they had a series of principles that they had to examine each proposal against. So they're focusing on enforcement. They're focusing, I think, on bad employers who didn't do things, like security companies that didn't pay their overtime. Suddenly, we need a big new rule with a big new penalty to deal with security companies. They're not realizing that it will affect their permanent secretary. If the pay office doesn't pay the overtime, they don't realize it will affect them with their housemaid or gardener. All of those kinds of things.
I understand there's a provision to pay overtime, and a new salary bracket has been set of 52,000. How is that supposed to affect employers?
Yes, well, what that is that there's now a provision. At the moment, there's an existing provision that all contracts except for management must set maximum hours of work per week, maximum normal hours of work per week, for the purposes of calculating overtime. It doesn't say in the Act how much should be paid for any overtime, or whether any overtime pay should be paid at all, right? So it on the face of it, it's flexible. However, some people think that the section means that there must be overtime pay at time and a half and double it. And I disagree, but that's one thing. What they want to do, what is proposed, is that they're bringing a ceiling of 52,000 and saying that everybody who earns $52,000 or less must have a work week that is 40 hours or 48 hours for the purposes of calculating overtime. That's quite revolutionary, and it's sort of kind of anti-modern, right? In modern workplaces overseas, people are not stuck at 40, 48 hours anymore. Like it's flexible. Some people want to work 80 hours this week so that they can have next week off. Or they want to have their hours averaged over 6 months so that they can do other things. But apart from that, apart from losing modern flexibility, what it does is that it will create big expenses for a lot of employers. For people, like overtime is fair enough for people who are hourly paid, because the more hours you work, the more pay you get. And hourly paid people don't control their work. They work under direction. But salaried people, we generally control how much we work. And if you're focusing in the day, you make up for it at night in your own time. This will affect that. It will make, if you stay beyond your hours, potentially you'll have to pay overtime. And that will affect government services, many employers who won't want to pay overtime.
And this law has been proposed at the time when the Public Service Commissioner of Ministry of Civil Service is stopping overtime.
Yes. So, in the government context, if this comes, at the moment, there's overtime is due to people, I think, 20-something thousand and below within government. It will mean those up to 52 will be entitled to overtime pay, so you won't work because there's no overtime. So it may interrupt services.
Based on what you have explained, the criminal offences, the fines that are in this proposed bill, how much money do you expect a small company to budget annually to cater for all this that is now being dropped into their hands?
You don't budget for criminal offences because you hope you don't do that. But the bigger issue, the bigger change that will affect budgeting is the time for grievances and disputes. At the moment, you've got to bring a dispute within 6 to 12 months. A dispute within 6 months, a grievance within 6 to 12 months. I can't remember, but they're short periods, right? And you can ask the tribunal to extend the time if there was a good reason. Under this, the time is being extended to 6 years. And that is truly revolutionary. What it means is that a union, remember unions generally claim pay rises by the year. An employer, a company, budgets for pay for that, increase for that year because they pay bonuses, they distribute profits, they budget for a year. This new thing will mean that a union can report a dispute over a pay claim 6 years ago that they made but didn't pursue, that broke down and then they left it. So 6 years later they can say, we're going on strike for pay going back 6 years. And the profits for those 6 years, the budgets for those 6 years are already gone. And it's crazy. Like, why somebody, an employee for a grievance, they've got a grievance that you spoke badly to me or you didn't give me my hours. They can hold that for 6 years before they raise it with the ministry. It's crazy.
You use the word crazy.
With all due respect.
Is that the overarching label we can put on this proposed bill?
No, I wouldn't. Don't get me wrong. There's some elements of the bill that are good. What I'm highlighting here are the things that really concern me that we need the ministry to hear the public on. I'm being alarmist here. I'm raising the things that the public needs to have a say about. But there are many, like I said, there's 140 sections. There's some good things in there. But some of the proposals are completely unworkable.
Has this proposed law come to the public knowledge in the spirit of tripartism, employer, employee and government?
The ministry says so. The minister says so. And I respectfully disagree. Okay, it's not tripartism to say we had a tripartite committee, so therefore it's tripartite. Okay, if the committee, the members of the board, were not allowed to consult the stakeholders, and to bring the concerns of the stakeholders into the discussion. The ER Act at the moment contains a requirement or obligation of good faith for employers and unions and workers. The ministry is fond of telling employers you've got to act in good faith. The duty of good faith requires the party to give all relevant information to the other party. And with all due respect, the ministry has not been giving all relevant information to all the stakeholders. They haven't given it to the employers outside of ERAB, they haven't given it to the unions outside of ERAB, they haven't given it to the workers of Fiji.
Final question. In my view, in your view, do you think this piece of legislation is being pushed onto the employers?
Yes, it's being pushed too quickly. Again, it's necessary, but we need full input on what's required and what the cost and effect of all these proposals are before the bill goes to cabinet. We shouldn't rush to make mistakes. We shouldn't rush to make bad law. We should take our time to make a good law, to make a good reform that meets everybody's needs that creates employment, that strengthens our economy, and that meets everybody's interests.
If no amendments are made, this law is put into an act, who will be blamed for its implications?
That's for the voters to decide, not me. I'm only one voter.
Mr. Apted, thank you very much for speaking to us.
Thanks.